Hi everyone, welcome to my channel Law Adhyayana. Today in this video we will discuss few new provisions in Bharatiya Nagarik Suraksha Sanhita. As per section 1 subclause 2, the provisions of the act except chapter 9, 11 and 12 do not apply to states of Nagaland and to few tribal areas. As per explanation in the act, tribal areas means tribal areas of Assam mentioned in Schedule 6 of Constitution. However, state government by issuing notification can apply the provision. The important change that had taken place in the present act is digitalization. And in the definitions part, under section 2(1) clause A defines audio video electronic means. 2 clause 1I defines electronic communication, and under section 2 clause 2 states that words used but not defined in the present act but defined in Information Technology Act 2000 and in Bharatiya Nyaya Sanhita shall have the meaning assigned to them in that act in the present act. And the few provisions in the present act that talks about digitalization are: as per section 105 of the act, search and seizure shall be recorded through audio video electronic means. And under section 173 clause 1, EFIR can be filed in cognizable offences. And as per section 530 of the act, all the trials, recordings and proceedings including summons, examination of witnesses, recording of evidence in inquiries and trials, and all the appellate proceedings can be held in electronic mode. And section 43 of the act talks about usage of handcuffs if the person commits heinous crimes like organized crime, terrorist act, murder, rape, acid attack, sexual offenses against children, counterfeiting, and offenses against the state. In this section, usage of handcuffs is allowed even in organized crimes. Section 52 of the Act allows medical examination of rape victim by medical practitioner upon the request of police officer. Section 173 clause 1 subclause 2 mandates woman officer to record the FIR when the offence is against the woman and is filed by the victim. Section 184 of the Act stipulates to send the raped victim for medical examination within 24 hours from the time of receiving complaint. And under the same section, subclause 6 states that medical practitioner should send the report to investigating officer within 7 days. Section 173 of the Act talks about zero FIR, which means that the FIR can be lodged in any police station irrespective of the crime where it has been committed. As we have discussed earlier that FIR can be given even through electronic means also, after receiving of the complaint, FIR has to be registered within 3 days. There is even time limit for the offences relating to cognizable offences, which is punishable for more than 3 years and less than 7 years. When the information is given in such cases, then the police officer has to conduct preliminary inquiry whether there exists a prima facie case within 14 days. Section 176 clause 3 of the Act allows forensic experts to visit crime scene and collect the evidence for cases punishable more than 7 years. Section 187 of CRPC talks about the detainment of person if the investigation is not completed within 24 hours. Then the police has to produce the accused before the magistrate, and magistrate can order detention of the accused for the first 15 days but not exceeding 15 days in the first 40 or 60 days. And under section 187 clause 3, the detention can exceed 15 days upon the discretion of magistrate but not more than 90 days in offences like where the punishment is imprisonment for life or death, and in other offences it's 60 days. Section 187 Clause 4 states that no person shall be allowed in custody of police till accused is presented before magistrate for the first time. And subsequently every time until the person remains in the custody of police. And subsequently the magistrate may extend further detention in judicial custody upon the magistrate's discretion. And chapter 22 of the Act talks about summary trials. And as per section 283 clause 2, the magistrate can exercise the jurisdiction of summary trial for all the offences which do not exceed 3 years of imprisonment. And section 359 of the Act talks about the compounding of offences, and the tables are mentioned in this section. Chapter 23 of the Act talks about plea bargaining. And as per section 290, in this chapter the limitation period for filing plea bargaining is 90 days. And section 479 talks about the maximum period for which the under trial prisoners can be detained. And the present Act had given time limit for filing of charge sheet, that is 90 days, and the maximum time limit is 180 days. And for framing of issues by the court, the time limit is 60 days. And for the pronouncement of the judgment by the court, the time limit is 30 days from the date of hearing of final arguments from both the parties. Thank you. If you like my video, please do like, share and subscribe to my channel.